purpose of calling. It is not limited for calling itself, but then there are so many things which has popped in and they help people to witness a better facility through their phone itself. So as you can see that when you inspire others, the technology gets developed, the product gets developed, and eventually it is the society which gets to enjoy the benefit of the creation. And hence, knowing the concept in a very clear manner becomes really important enough. So let me share my screen first of all so that we can officially begin with the presentation and we can, start the session. So today's topic is going to be intellectual property rights. When we take setup, we can see that patent related and design related information is sought in a very detailed manner. And that is why we are going to have a brief overview on different type of IPs and a slightly elaborate view on patent and design process. As already introduced, my name is Pooja Maulikar. I am working as an examiner of patents and designs at Rajiv Gandhi National Institute of Intellectual Property Management. This is a training center. As ma'am has said, a lot of activities are happening through this office. In case you want to have any free program, customized program, you want to become a part of the trainings which we are organizing, for any of your official concern, you may write to us officially at rgniipm.ipo@nic.in, and we are available at the website ipindia.gov.in, wherein detailed information is already available regarding different IPs. So you can take help of the website to enhance your knowledge. This particular program is getting organized under NIPM, which is our National IP Awareness Mission. This began last year to celebrate 75 years of independence, and we have taken this noble cause of creating awareness among general public. Since we have started it last year, we have already reached more than 10 lakh people creating basic awareness about IPs. And since the cause is really noble enough, we are continuing with this mission so that we can create awareness among general public as such. So right now we are going to discuss the basics, but whenever you want to have elaborate information on IPs, it is suggested that you refer to the acts and rules which are specially designed for different IPs as such. So there can be any government order also imposed on a particular type of IP at a particular time period. So you have to take a note of the same as well whenever you go for drafting, filing, etc. But otherwise also whenever you want to enhance your knowledge, it is suggested that you refer to acts, rules. They are written in a very elaborate and a very to the point manner so that it can give you a proper direction as to how you should proceed to understand IPs as such. We are available at different social medias like Facebook, Twitter. They being the popular platforms for a longer period of time. We have been available here so that we can, of course, reach maximum number of people, create visibility about RGNIIPM, quick sharing of information can happen. So upcoming training programs, upcoming endeavors are floated here so that people can get to know about the activities which are going to happen and they can become part of the same so that they can benefit it from the trainings and endeavors and steps taken by. So we have Rajiv Gandhi National Institute of Intellectual Property Management. This is a training center located at Nagpur. In the same campus, we have PIS. This stands for Patent Information System. This started last year. This started during the times when a lot of difficulty was being faced by public to find out particular piece of information. So to help people um, get access to a particular piece of information related to which might be having relevance to their patent, this office has started. So it has started way back. Now we can see that a lot of development, technological development, internet facilities has reached various nook and corner of the country, and that is why people can find information easily over internet itself. But still, this office is functional. We have 4 patents and design offices in our country. These are located at Delhi, Mumbai, Chennai, and Kolkata. So these offices are jurisdiction-based offices. If you divide our country's geography into various geographical zones, you would see that we have placed one office in each zone, and people residing in a particular zone have to file their patents and designs applications only in the office available in their zone. Next, we have trademark registries. These are located at 5 locations, that is Delhi, Mumbai, Chennai, Kolkata, and Ahmedabad. Geographical Indications Registry is located at Chennai, and Semiconductor Integrated Circuit Layout Design Registry is available at Delhi. Apart from this, we have Copyright Registry again functioning from Delhi. These are the pictorial views of our official buildings located at different locations, that is Mumbai, Chennai, Kolkata. And this is a building of RGNIIPM Nagpur, which is centrally located in the country. If you're familiar with Nagpur, we are nearer to Islam College, opposite to board office, near to Bird. We are available at civil line. Conduction of training is available here. We have good classrooms, computer labs where practical sessions could be conducted. Not only this, we also we have developed various training skills, etc. And people who enroll for the program should not be facing any difficulty during the official hours. Is the intention behind meeting all the requirements during the official hours. Now, beyond this, we have started virtual trainings also with the pandemic, so that we can keep the learning aspect unaffected. So all the trainings are like right from 1 hour of free workshop, then it extends like 1 day, 2 days, 3 days, 5 days, up to 2 weeks. We conduct various combination of trainings. The topics, durations are decided by RGNIIPM, and it is the information is floated on the website and other platforms so that people can get to know about the upcoming events. All the training programs are certificate based training programs. We also have associations, collaborations with international bodies for training to be conducted for our internal officers and federal public. So we have the famous international public training program as WIPO India Summer School. So WIPO basically stands for World Intellectual Property Organization. They are headquartered at Geneva, Switzerland, and they conduct summer school with some of the countries. Once in a year, we have it in India also. After meeting the basic requirement of the training, any individual can enroll for the program. Now, this is the official website, ipindia.gov.in. When you enter into the page, you'll find different separate tabs provided for separate patents, designs, trademarks, GIs, RGNIIPM. So when you take your cursor to a particular IP, the drop-down column comes giving further information about the IP, like quick information, forms, phases, frequently asked questions, etc. We have started e-filing facility also, so that individually you can go for filing at your comfort zone. Public search platform is available. This will give you particular information about your IP, so that you can conclude how far it is protectable, comparing it with the prior public information, which can be searched through public search. Now, publications in the form of journals, annual reports, newsletters are also available. They give further insights on latest happenings in the office and developments in the office. Acts and rules have been provided. This can be readily referred, and you can have a reference of the same. Manuals have been provided for easy understanding of acts, rules, and guidelines for particular type of IP. Topics have been suggested so that you do not face difficulty in filing such work. The website is really updated with all the news, updates, tenders, notices, and upcoming events, etc. Now, every year we celebrate World IP Day on April 26. This year, the theme is IP and Youth, innovating for a better future. So, better future is directly associated with IPs and youth when they go hand in hand. It is seen that this present century is focusing on knowledge, and hence it becomes really important that we come up with creation and processing of knowledge so that a nation's ability to translate their knowledge into wealth and goodness could be achieved through IPs. Now, when we aim to have national development, it is so obvious that we rely on education system, which is the influential system to bring in any sort of change. Hence, adoption of various standards and appropriate methods at school level, higher education level becomes important enough to come up with skill improvement, and this eventually reflects into the national growth and development. So, when students protect their work under IPs, it helps them to have added value in their profile, safeguard their creations, get differentiated from the mob. Now, this added value in the profile might help them to get good opportunities further for further studies, um, and extra weightage during job interviews. Um, and you can also if you aspire to become young business owners, you can do so by protecting your work initially so that it does not get copied easily, and you can protect safeguard your creation. When IPs are being commercialized, of course it can help you to generate revenue, which gives further motivation, and improvement can be achieved in the IP which we have already launched into the market. Now, schools, colleges, when they protect their work under IPs, it helps them to have enhanced reputation, collaborative opportunity for further improvement with other institutions, for exchange of resources, for better projects to be taken, for internship opportunities to be created, etc. And industry academia relationship, if you see, industry is basically having various small issues which could be resolved through academic setup, having great assistances through the library, laboratory, and experienced faculties, etc. So when they combine together, of course, such industrial problems could be solved, and the bond between the same, that is between the industry and academia, can be strengthened. Now, revenue which gets generated is, of course, giving more motivation to all the people who are involved in it, like the inventors, applicants, institution, the industry, everybody gets benefited. Now, when you look at the term intellectual property, there are two individual terms in it, intellectual and property. Property, whenever we hear, what obviously comes to our mind is something which is tangible in nature. That is, they are measurable in some or the other parameter, like you can touch them, feel them, see them, etc. But they again can be classified into different heads, like movable and immovable assets. Movable are obviously the ones which can be located from one location to other, like vehicle. They are basically an output of a human brain. So brain is having a beautiful capacity of thinking, analyzing, associating knowledge known to the brain, the conditioning done on the brain, and the type of experiences the brain has come across. Based on all these factors, there is a possibility of ideas and expressions being proposed by a human brain. These ideas are so important. They, of course, are intangible. You cannot touch an idea, you cannot feel an idea, you cannot compare it with something valuable, etc. But of course, when you work on it in a proper direction, the final output can be achieved, like a product, process, a design, a logo, artistic aesthetic creations, etc. And this eventually will help you to develop some sort of property. And that is why it is termed as intellectual property. So these ideas, as I've said, are the raw initial point, beginning point. This needs to be supported with further resources like time, energy, efficiency, labor, etc., information, and stuff like that, so that you can work on it, the final form can be achieved, and based on the characteristics of the final output, you can register them under a particular head of IP. So eventually, you get intellectual property rights. These rights are exclusive in nature. The entire right to make it, sell it, remains with the person who has protected it under their name, but these rights are valid only in the country where you have filed for it. So, where you have got the grant after filing, there exactly you can enjoy the benefits. These are licensable rights as well. The licensor, licensee, market. everybody gets to enjoy the benefit of this licensing system. Now let's have a look at different type of IPs. We'll begin with patents. Patent is basically, the exclusive right given by Government of India to the person who files for it for a period of 20 years from the date of filing, and this is in consideration of full disclosure of the invention. You have to be really clear that there is nothing called worldwide right, global right, or international rights. These are purely territorial rights. Now, when we talk about patents, people normally feel that people from scientific background, engineering background, science background only has relevance to patents, but it isn't so. There are different things which are developed by others and they have been protected. We have been using them as such, and in case it does not mean that your expertise lies in, let's say, biology backgrounds, then you cannot create something which belongs to mechanical or electrical background. If your understanding is good enough, you have learned that concept, you have developed something as an output of your learning and analyzing, etc., then you can, of course, get the work protected under your name. Of course, it has to be your original creation. Now, when we talk about patents, people feel that only critical stuff, difficult stuff get patented, but it isn't so. There are simple stuff which we are already using in our day-to-day lives. I would like to quote few examples so that you can be comfortable with the term patents. So I hope all of you would have seen this. This is a paper clip. It was invented in the year 1900 by Johann Waller at Norway. It is nothing but a simple wire twisted and turned thrice in such a manner that it can hold papers together. Ballpoint pen, irrespective of our professional lives, we do use ballpoint pen on a regular basis. This is also one of the inventions which we are using on a regular in our day-to-day lives. So it was first invented in the year 1888 by John Law. A lot of versions of pen did come, but it is to be noted that this particular type of pen is into the market because of its user friendliness and cost effectiveness, etc. Bluetooth is also one of the inventions which we are using on a regular basis. It was invented by Jack Hudson in the year 1994. It is an option for data transfer. Electric light bulb is probably one of the famous patented invention known to mankind. And Thomas Alva Edison has invented this in the year 1878. Telephone is also one of the inventions which we are using on a regular basis. As I initially also said, we have been using the phone for some time. But the first telephone was invented and patented by Alexander Graham Bell in the year 1876. He was inspired by his hearing impaired mother and wife, and that is why he has come up with this device so that he can provide an improved communication device to the world. Prathamesh, who is an Indian national, is visually impaired, was facing difficulty in learning during pandemic, and hence he has come up with a smart brain learning device, which can be helping visually impaired people to keep their learning aspect unaffected. Now, invention and discovery are different. Invention is all about stuff which are naturally known. When you find out such stuff, it can be called as discovery. So any new thing, property of known material or article having no technical effect on the part of mankind are basically termed as discoveries. They are not patentable. They are all about man-made process or products. Either they has to be new or inventive in nature. So by inventive, We mean improved product or process, either technically improved, economically improved, or made economically significant, or both at the same time. Plus, it should not be obvious enough. Apart from this, it should have industrial applicability also. If all this is satisfied, we call it as invention, and inventions are protectable under patents. Now, most important thing done before you go for patent filing. And second important thing is that you should always be sure about completion of your work before you go for patent filing. Now, half done work or partially done work when filed under complete patent filing application, it might create hurdle in you adding further information, and hence it is suggested that you be patient enough till you complete your work and then go for filing. Next most important thing is that you always compare your work with the prior public information. There are different pre-patent search sites also. Like IP India has its own public search platform that could be utilized, or you may utilize Google Patents. WIPO, which I have already quoted with respect to summer school, this WIPO has its own website. So therein they provide a search engine named as PatentScope. There are different IP offices which are providing their databases free of cost. Like we have eSpaceNet provided by European Patent Office, we have United States Patent and Trademark Office, Japanese Patent Office, and other IP offices which provide their databases easily. You can have access to the same through the internet. Now, for patent and design filing in our country, there are four categories which are allowed. First is individual person category, or you may call it as natural person category. So individually or in group, people may go for filing through this category. Next, second is any entity which is legally established, like a company, institute, R&D center, etc., can file under this category. Third is small entities which are recognized through MSME Act. And lastly, startups are also permitted to file patents and design applications in our country. As per your territorial jurisdiction, you should be filing your patent and design application appropriately. Now, the way you write any project report in a similar manner, a patent specification is to be written, giving a suitable title, discussing aims, objectives, technical field, background art, like what was known before, what was lacking therein, what motivated you or inspired you to come up with this invention, etc. Then, like any other project report, you elaborately disclose your work, like material, from where you got the material, what methods you have utilized, what experimental procedures you have undergone, what are the results, analysis. You can take the help of drawing, abstract, summary to explain the concept in a proper manner. But apart from this, in a patent specification, you have to justify industrial applicability of the work, which otherwise you do not do in any of the project reports. Apart from this, you have to give the statement of claims. This also you will not write in any other project reports. Now, what are claims? They are the single statement about your invention, which will help you to understand which will help the examiner to understand that these are things for which you are seeking protection in lieu of whatever you have disclosed in the entire specification. There are 30 forms in patent office, but these are the basic forms which everybody should be knowing. First 5 forms are the minimal requirement of patent filing. Next few forms are the optional forms which everybody should have a knowledge about. Now, first is application form, which comes on form number 1. Basic details of the applicant, inventor, declarations are to be submitted here. Second is specification details. Third form is for foreign filing details. In every 6 months, you have to file this form, even if there is no filing in other country. Apart from this, inventorship details are to be declared on form number 5. And we have the important form that is request for examination. This comes on form number 18. Now, this is to be filed up to 48 months. You can file it from the date of filing of form number 1. And that is why I have highlighted it separately. But the thing is that sooner you file it, sooner it appears into the examination module. Apart from this, we have also started expedite examination through form number 18A. This form will help you to get your examination report generated within a month. Now, certain optional forms are like in case the applicant is a startup, MSME, or institute, you have to justify the status of being so through form number 28. publication of every application takes 18 months of time, during which we float the basic information of the application in the public domain so that public gets to know what is being filed, who has filed it, what technology has already been developed, etc. is the intention behind the basic publication. This takes 18 months of time, and after this only examination and rest of the procedure starts. So in case you want to save this 18 months time, then you can request for form number 9 through which you can save these 18 months time. Now, ideally, filing can be done on an individual basis also. But in case you want to appoint a patent agent from the list of registered patent agents, then you can do so. But you have to give power of attorney to that particular agent on form number 26 and submit it to the office so that we can take that into a record. Next, the basic online filing fees for form number 1 for natural persons, startups, MSMEs, and institute is 1600 rupees, and for others it is 8000 rupees. Form number 2 has a permitted limit, that is 30 pages, and within these 30 pages maximum 10 claims are allowed. But the moment you exceed this limit, it is chargeable as per your category. Hard copy filing would also cost additional approximate 10% fees over the online filing fees. Form number 18 would cost you 20,000 rupees for others category, and the fees for rest categories is 4,000 rupees. As I've said, expedite examination can help you to get your examination report within a month, but this has a permitted categories list who are only allowed to file this form. So these permitted categories are SMEs, startups, government organization, PCT application, filed in India, signing India's ISA, natural person category wherein one of the applicant can be female. Now, early publication will help you to get your application published within a month. For filing, either physical or electronic filing mode can be adapted. For physical filing, you can go to the office counter directly, or you can send your application through Indian Postal Service. For e-filing, you require either class 2 or class 3 digital signature, or e-hastakshar, e-signatures will also do. Now for online filing, the login ID and password is to be generated, and you have to submit all the forms as stated before. Eventually, after making the payment, you can submit your application through digital signature or through e-signature. Now, lastly, it is once you file your application, it is made sure that it is being digitalized. Like if it is filed in offline mode, then it is being digitalized. All the applications are screened, classified, and it is published after 18 months. And after this only, request for examination is considered. It is allotted for examination, wherein formal and technical evaluation happens of every application, and you get the first examination report. In case there is any in case there is any lacuna in the um, application, that is to be rectified through the FER which is being issued. This reply is to be given within 6 months, and after this also, in case something is still left out which needs to be rectified to put that application in the order of grant, then you may expect a second examination report or a hearing before the grant or refusal of the application. Now, finally, when you get the grant, the certificate looks like this, giving you basic details of the application. Next type of IP is designs. Design is all about outer look of the product, like shape, configuration, pattern, ornamentation, composition of lines, colors, combinations, etc., which can be applied in 2D or 3D or in both the forms. So, as you can see, design will help people to beautify the product, attract customers, and it will also reflect in the sale of the product. So the initial year of protection for design is 10 years, and beyond this, 5 years would be the period of protection of designs. So whatever you can see on your screen with respect to various products is basically um, the unique design which needs protection, and this can be availed through design registration. So there are different things which are already into the market, like we have. So these are not restricted to clothing only, which people normally feel that design is having relevance to clothes, etc. But there are different consumer products wherein design can play a big role. So right from the comb which you use till the footwear which you are wearing, apart from that, the brush which you pick early in the morning till the last thing which you pick at night, that is the alarm clock, every product has a scope of getting beautified, and this reflects into the sale of the product. So as I was saying, this is not restricted to textile and jewelry alone, but there are different domains wherein IPs can play a big role, and specifically designs as well. It is also seen that small business owners and startups are also using designs to beautify the product, to attract customers. They are also being utilized to um, for having a better packaging system, etc. For design filing, you need to remember that your work should be original enough, distinguishable. It should not be contrary to public order, morality, or security of India. There are 32 classes laid down by design office based on the nature and function of your article. You may choose a particular class wherein you feel the protection is to be availed. Now, form number one is to be filled, giving basic detail of the applicant, article, class number, etc. And various views of the image product is to be submitted so that you can justify the unique design. Now, the fees for online filing for natural persons, startups, MSMEs is 1,000 rupees, and for others it is 4,000 rupees. Form is really easy enough. It is self-explanatory. Anybody can easily fill this form and submit their application. Along with the application form, the representation sheet is required. This should be supported with a novelty statement and a disclaimer statement. Now, since it is all about the image which will be taken into consideration for evaluation, we need to make sure that the quality of the image is really good enough. The background is clear, the lines, colors, combinations are clear enough, and in one single application, single design should be filed. Though set of articles may have same design, but set is understood, like table and chair being a set, sofa set, crockery set, a pen and its cap being a set, etc. So these units can have same design, but irrelevant items combined together are not allowed under set. And moreover, variation in the set is not allowed. Normally, a pair of gloves comes with one unit for left hand, the other one for right hand. If you bring in variation there and bring two individual units for, both the units having different design, or both the units belong to one single hand only, then such variations are not allowed. Depiction of living or dead person is also not allowed under design registration. So all the trademarkable and copyrightable content are not registrable under designs. Uh, Non-registrable designs include calendars, certificates, postcards, greeting cards, maps, labels, cartoons, etc. And next type of IP is trademark. It is also called as brand name. It is nothing but the visual symbol in the form of a word, name, symbol, numerical, combination of colors, etc. Um, this is to indicate the source of the good, to distinguish your product from rest of the products available in the market. And in case you find R encircled in front of a trademark, it means it is a registered mark. So duration of registration initially is 10 years, and it can be renewed in every 10 years. So there are different types of trademarks also known in India. Some of them are word mark, letter mark. Um, combination mark, mascot logos, emblem logos, etc. There are different Indian trademarks and brands that are doing really good in the market, like Tata's, Bajaj, Kirloskar, um, Hindustan Motors, Indian Oil, etc. So for trademark filing, you have to fill in TMA form, that is registration of trademark application, and the fees for online filing for sole proprietor MSMEs is 4,500. For rest, it is 9,000 rupees. Next is geographical indication. This is all about the place name which becomes famous with respect to any product made or grown in that location, having unique originality, quality, reputation, or any other characteristics. So, Darjeeling tea, Kanjivaram silk sari, Punapuri chappal, Nagpuri oranges are some of the examples of GIs. So this is not an individual right. People involved in making or growing of such products will form an organization and they are allowed to file a GI application. Initially 10 years and beyond that every 10 years the right can be renewed. Further examples could be basmati rice, Alfonso mango, Bikaneri bhujia, Tirupati laddu, etc. Now, this is a very famous type of IP, copyrights. Copyright is all about literary, artistic, aesthetic, cinematographic, or software related content, etc. So, life of the author plus 60 years is the time period of protection of copyrights, during which unauthorized copying and reproduction could be stopped. So, all the creations like books, movies, music, painting, software are considered under copyrights. So as you can see, there are different types of IPs which are existing, like patent, design, trademark, copyright, GI. Each one is different from the other. Initially, when you talk about patent, it is given for inventions like any product, process, device, compositions, etc. Wherein the concept has to be new, inventive, industrially applicable, and it should not fall under the category of non-patentable inventions. Initially, the period of protection is 20 years from the date of filing. Next is designs. It is all about the outer configuration of the product, wherein you can beautify the product, attract customers through the unique design. Initially 10 years and beyond that 5 years is the period of protection of copyrights, designs. Trademark and GI has the same period of protection, that is 10 years initially and it can be renewed in every 10 years uh, subsequently. But trademark is given for the logos through which you can establish your unique identity, and GI is given for place names which are specific for particular product made or grown in that location. Lastly, we have copyrights. This is all about artistic, aesthetic, cinematographic, literary, software related content, wherein life of the author plus 60 years is the time period of protection of copyrights. Now, the beautiful thing is that whichever product you're using, when you pick that, you may find different IPs there. So I've taken a simple example of camera system. So the automatic exposure control mechanism of a camera system is coming under the purview of patented rights. This is given for a period of 20 years from the date of filing. Next, the name under which the camera system is sold, that is, here it is Canon. There are different brands also like Kodak, Sony, and many other brands are there. So these are the example of trademarks. So initially 10 years and beyond that every 10 years you can renew the protection period for the trademark. Design is all about the outer look of the product. Initially 10 years and it can be extended for 5 more years beyond this. And the catalog, booklet, user manual which you get with newly purchased camera system is coming under the purview of copyrights. So in general, whichever product you pick, normally the constructional features come under patented rights if they fall under the category of inventions. The outer look can be registered under designs. The name under which the product is sold can be registered under trademarks, and the book catalog, booklet, and the user manual can be registered under copyrights. Now there is one more thing, that is integrated circuits. So in case you find that there is integrated circuits involved in the inside make of the product, the layout of the integrated circuits can also be protected under semiconductor integrated circuit layout design. Lastly, we have one more concept which needs no registration anywhere, but that is known as trade secret. So it is individual persons in the market to get distinguished in the market. Like combination of both can be a trade secret. So likewise, there are different IPs which can be developed and which can be protected for better protection of the IP for that concept. So this is all about the basics of IPs. As you can see, IPs are existing in various domains. It is not limited to a product, technology, etc. It is having relevance in leverage also. So likewise, it is having relevance in various products which are you are using on a regular basis. So this is all about the basics. In case you want to contact us further, our official email ID is rgniipm.io very carefully so that we do not there is no need to reissue the certificates for which we do not have any provision.